Assalamu alaikum and hello to everyone. This is the course of international criminal law, and we are in the week of 5 in this course. And today's lecture regarding the further continuation of the understanding of the jurisdiction of the states to regarding the liability of the criminal liability of the international criminal law. So in this week we are beginning with the topic that is the remaining last topic of the jurisdiction, that is the universal jurisdiction under the international criminal law. So students, I hope you will enjoy enjoy this lecture, and this lecture will give you further knowledge regarding the course which we have started in our course, that is the LLM course. So here's the today's lesson plan and slides which is I'm going to share with you. So students, here's the international criminal law course, that is in LLM. That is the summary of lecture which is prepared by me for you, and this summary which will cover both weeks, week 5 and week 6, regarding the jurisdiction and prosecution. So and then in this week the lesson plan which I have designed for you, that is the jurisdiction under international criminal law and the universal jurisdiction. We will learn, we will discuss that is the universality of the jurisdiction, and after the break, the second part of today's lecture will cover the ad hoc and hybrid mixed tribunals which were created for this specific purpose. So our lesson 1 probably cover the universal jurisdiction of the criminal law, and lesson 2 of this week we will discuss the ad hoc and hybrid and mixed tribunals. So here is the, and in next week we will discuss the national and international prosecution. So in this week, this is the lesson 1, and in this lesson before break we will discuss and we will complete inshallah in this week, but probably in this week we will discuss, because the ad hoc and I will start this lecture with the introduction, and thereafter this lecture will followed by the approaches of the universal jurisdiction, the rise of the universal jurisdiction, the decline of the universal jurisdiction, and as usual I will conclude my today's lecture with the discussion of the case law, that is the case problem which is already decided by the course, and universal jurisdiction, practical problems and policy-based political criticism of the universal jurisdiction. And thereafter I will share with you reading material which if you will follow those reading materials, you will cover all these topics with good knowledge. So students, I'm going to start today's lesson with the introduction of our topic, that is the universal jurisdiction. There are 4 jurisdictions which we have already discussed, but in today's lecture, what is the universal jurisdiction? So here is the introduction of the universal jurisdiction, that is the universality principle in its broad sense implies that a state can claim jurisdiction over certain crimes committed by any persons anywhere in the world, so without any required connection to the territory, nationality, and special state interest. Earlier, we have discussed how to determine the factors of the jurisdiction of the states, which will depend upon the territory and nationality and special state interest. But this is the universal jurisdiction. Any state claim jurisdiction if the crime which come in the ambit of the universal jurisdiction. Students, before this, we have discussed the four forms of the jurisdiction, which require some kind of link or connection with the prosecuting state. Whether that link is based on the territory where the offense took place, the nationality of the perpetrator or the victims, or the involving a threat to the interest of the state concerned. The application of the universal jurisdiction to a particular offense does not require any such link. And any state may assert its authority over offenses that are subject to the universal jurisdiction. So, due to the broad extraterritorial competence encompassed by the exercise of the principle of the universal jurisdiction, it is reasonable that only a very limited number of the offense can be subject to the application of this principle. And before we proceed with this analysis, we have to learn. We have to understand, and which we have keep in our mind, that the universal jurisdiction is probably the most controversial principle of the jurisdiction in international criminal law. It is certainly the most discussed and mostly come in our mind. So, what is the applicability of that jurisdiction? The term universal jurisdiction refers to the jurisdiction established over a crime without reference to the place of perpetration, the nationality of the suspect or the victim, or any other recognized linking point between the crime and the prosecuting state. It is a principle of jurisdiction limited to specific crimes. So there are those who deny that universal exists at all. But the view more consistent with the current practice is that the other than piracy, which is subject to the universal jurisdiction, due to it occurring by definition on the high seas, states are entitled to assert universal jurisdiction over war crimes, crimes against humanity, genocide, and torture. Those crimes are defined in the customary laws. So there are no example of universal jurisdiction prosecutions for the aggression. So this is the simple, very precise introduction of the universal jurisdiction. So what we have understand that the certain crimes which committed by any person, any state can claim jurisdiction over those crimes. Like crime of genocide, and crime against humanity, piracy. So any state can prosecute those crime within their state. And so these are the students. Further, in order to understand the introduction, so these are the points, these are the principles which govern the point of the universality. Number one principle is that determining jurisdiction by reference to the custody of the person committing the offense. And the first point determine the first principle of the universality. So the second principle, there are certain crimes which are so destructive of the international order and are the contrary to the interest of the international community as a whole, that they are treated as the delicta jure gentium, which means crimes under the international law. And number three principle is that generally accepted that all states are entitled to upper hand and punish the perpetrators of crimes under international law, regardless of their territorial and national link with them. Number four principle Purpose of conceding universal jurisdiction is to ensure that no such crime goes unpunished. The principle of this jurisdiction is that no crime can be unpunished. It is duty of the every state to prosecute and investigate the those acts which are not acceptable at all. Crimes which are subject to the universality principles are very limited in number. The clearest and non-controversial illustration of such crime, which is the piracy, for the centuries, there has been a true universal jurisdiction of the piracy. That is the first universal crime, which internationally any state prosecute the crime, that is the piracy. So slavery is too generally regarded as the being a subject to the universal jurisdiction. And as far as war crimes and crimes against humanity are concerned, references especially made to the 1949 four Geneva Conventions and the obligations of the state parties to punish persons guilty of these crimes, which is mentioned in the Article 49 Convention, now one of the Geneva Convention. Principle 9, due to the almost universal adherence to these conventions, which are signatory of 194 parties, it is generally accepted that the grave breach of these conventions, war crimes and crimes against humanity, are subject to the universal jurisdiction. The same is true with the crime of genocides, which was a subcategory of the crimes against humanity, but has later been regarded as a separate international crime. Attorney General of the government of the Israel versus Eichmann. Eichmann was the head of the German Gestapo and the charge of the policy that led to the extermination of Jews in Europe. He was found in Argentine in 1960 by Israeli agents and abducted to Israel. There he was prosecuted for war crimes, genocide, and crimes against humanity. He was convicted and sentenced to death. It was held by the court that the abhorrent crimes are not crimes under the Israeli law alone. These crimes are grave offenses against the law of nations itself. So, delicta jur gentium, the jurisdiction to try crimes under the international law, is a universal. So, this is the one of the good case, Israel versus Ichman, regarding the understanding of the universal jurisdiction of the universality of the course can be determined. So this case will give you a broad picture in order to understand this point regarding the jurisdiction. So 11th principle of this point is that as far as torture is concerned, there is a Torture Convention 1984, and there are 144 states who are signatory of this convention, and the torture is one of the recognized crime of the universal nature. 12th principle is that in the case Lord Millet stated, the systematic use of the torture on a large scale and as an instrument of the state policy had joined piracy, war crimes, and crimes against peace as an international crime of universal jurisdiction. So, therefore, the clear-cut cases of the international crimes which are subject to the universal jurisdiction are genocide, war crimes, crimes against humanity, torture, piracy, and slave trading. So these are the recognized, established crimes which are here we called it the universal type of the crimes. So any state can prosecute these type of crimes if committed within their territorial jurisdiction or outside their territorial jurisdiction. So number 14 principle is that other crimes of international concern established by the more recent conventions relating to the hijacking of the aircraft, sabotage, terrorism, hostage taking, and drug trafficking raise question as to the legal basis of the alleged universal jurisdiction. And number 15 principle, such conventions create an obligation to prosecute or to extradite the accused. So it is, however, difficult to accept that such treaties, which are binding only among the parties to them, by themselves create true universal jurisdiction in relation to the non-parties. Before the Second World War, such universal jurisdiction has been considered as contrary to international law by common law countries, except for acts regarded as crimes in all countries and crimes against the international community as a whole, such as piracy and slave trade. After the Second World War, universal jurisdiction has been universally recognized over certain acts considered as the international crimes. Furthermore, international crimes are those crimes which are committed against the international community as a whole or violation of the international law and punishable under it, such as war crimes, crimes against peace, crimes against humanity. And in recent years, crimes such as hijacking of aircraft, violation of the human rights, and terrorism have been added to the list of international crimes. And today, under the universality principle, each state and every state has jurisdiction over any of the international crimes committed by anyone and anywhere, which we have discussed or I have mentioned earlier. Those crimes like genocides, torture, these are the recognized international. So, students, before we proceed with this analysis, it is imperative that some clarifications be made. A criminal offense, for example, torture, is established as a such within a state by its competent authority, namely its parliamentary body. In this sense, torture becomes an offense under the national law. The same offense of torture, however, can also be promulgated by the competent sources of the international law, that is the treaty and custom. So, in the context, torture is defined as an offense under the international law, and even though both its subjective and objective element may be identical to the national provision, a crime under international law is subject to the interpretation and limitations of the international legal regime that formulated it. So, crime under international law, international crimes have customarily attracted universal jurisdiction in two independent ways. Number one, based on the heinousness of the crime, the nature of the crime, the degree of the crime, which is repugnant nature and scale of the offense, as is the case with the grave breaches of the humanitarian law and crimes against the humanity. And on the basis of the inadequacy of national enforcement legislation with regard to the offense committed in location not subject to the authority of any state, such as the high seas extension of universal jurisdiction over piracy under the international law, has substantially contributed to combating this scourge. It cannot be overemphasized that these two bases for the attracting universal jurisdiction are independent and conjunctive. The practical significance of this observation is that to discern whether or not an international crime is subject to universal jurisdiction, one must first ascertain which of two bases, nature and scale, or what of an act perpetrated on the high seas is appropriate. So this student, it was the simple introduction of the universal jurisdiction.